case briefs, and so much more. LSData's got what you're looking for.
A 2003 Supreme Court of New Mexico case, Lozoya v. Sanchez, focused on whether a person carries a responsibility to care for their injured spouse, whether legally married or not. The case contended that a valid loss of consortium claim depends on proving an intimate familial relationship and mutual consent to be married, followed by mutual assumption of marital rights, duties, or obligations. Ubaldo and Osbaldo Lozoya were injured in 2 car accidents and sued 2 defendants for negligence. Ubaldo's partner, Sara Lozoya, was granted a claim for loss of consortium for the second accident since they were married by that time. However, their first accident claim was denied due to their lack of marriage. The court ultimately ruled that a claim for loss of consortium could be extended to unmarried cohabitants in certain circumstances. The court upheld all claims except the loss of consortium and Mr. McWaters' non-negligence. A new trial was required for those issues, and certain evidence was excluded from the trial.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class